So when I started the arbitration boot camp, it was on the basis that I wanted to have some practical information that I couldn't necessarily find in texts. So this is what I hope I'm achieving for those of you who are regular viewers. I'm a partner at Learners, and an arbitrator on the Arbitration Place roster, and I'm also an editor and a writer for Arbitration Matters, which is a blog posted on a website called Arbitration Matters that provides summaries of cases as they're released across Canada with some commentary to explain why they're significant and important to Canadian arbitration law. After this session, you will get a copy of this recording. You'll get links to the various cases, etc., that I talk about. And as I said, you'll get a list of the previous arbitration bootcamp topics. I've got a Q&A box open. If you've got any questions while I'm talking, please do put them in the Q&A box, and I will keep my eye on it. And if I don't reach your question while I'm talking, I will get to it in the end. I will have you out by 1 o'clock, guaranteed. So today I am talking about Aroma and the duty to disclose, and I put a question mark in my title, which is the final word on the duty to disclose. And I'm sorry to tell you that we don't have the final word on the duty to disclose from the Ontario Court of Appeals decision. Before I start, this webinar has been accredited for 1 hour of professionalism credits. So let's start with Aroma. The scope of the duty to disclose has been topical for about 2 years because of both the Aroma case and the Vento case. And those cases have made their way through the Ontario courts to the Ontario Court of Appeal, and both of them were denied leave to appeal by the Supreme Court of Canada this year. So this is all we're going to know about those cases. I'm going to focus on Aroma today because it really is the significant duty to disclose case, and then I'll say a few words at the end of my remarks about the Vento case. And so, just to give you a preview, where are we? The Aroma case, the Ontario Court of Appeal decision, confirms the long-established view that the test for bias is objective, but for reasons you'll hear about in a moment, I say that this decision, the Ontario Court of Appeal decision in Aroma, is a departure from the international arbitration law in finding that the duty to disclose test under the model law is also objective. It makes Ontario an outliner both in Canada and internationally. And from that perspective, it's too bad that the Supreme Court of Canada has denied leave, because this is, I say, the most difficult issue which is facing arbitration practitioners at the moment. The duty to disclose, when does it arrive? And part of that is because of Aroma. And after the lower court decision of Aroma was released, all the arbitrators that I've spoken to, including me, have changed their disclosure habits and are now making far greater disclosure than we would otherwise have and did in the past. So it's had a significant effect on practice. And there's a lot more uncertainty than there used to be about when the duty to disclose arises. So let me start with some of the basic principles as a background to the Aroma case. Principle number one, independence and impartiality. An arbitrator must be both independent and impartial from the time of the appointment all the way through to the conclusion of the arbitration. And that includes the 30-day period found in the domestic and international arbitration for corrections to the award. And this duty of independence and impartiality arises unless the parties agree otherwise. So, for example, under Ontario and Alberta, there is a specific provision in the Arbitration Act, Section 3, which says that parties can opt out of specific provisions of the Act. And the independence and impartiality provision is one of those that parties can opt out of. Under the BC Domestic Act, the arbitrator must be independent unless the parties agree otherwise, but must be impartial. So why would someone ever contract out of the independence requirement? And one of the reasons that I can think of is that there is a very small market in particular kinds of arbitrations. franchise, rent review, arbitrations, that sort of thing, where the players are repeats. They see one another again and again. And so there are certain relationships that in a broader market might create situations where parties might object to the independence of the arbitrator, which really is all about the relationships that the arbitrator has with counsel and perhaps parties and witnesses. But why would a party ever opt out of impartiality? And I don't have a good answer to that. And if anybody does, please put it in the Q&A box, because impartiality is really all about the state of mind of the arbitrator, which is that the arbitrator is in some way predisposed on an issue or with respect to certain parties. And this is demonstrated, this lack of impartiality when there's a challenge is demonstrated by the conduct of the arbitrator in the hearing. And it's often an issue raised about how the arbitrator conducted themselves by interjecting more, for example, in one party's case than another. So, in my view, really best standards and what should be desirable to the parties in ideal circumstances is both independence and impartiality. So, that's the fundamental backdrop. We then get to the test for disqualification of an arbitrator for lack of independence and impartiality. And there are two bias tests, there's an international one and a domestic one. The reasonable apprehension of bias test is one that we most see in the domestic acts, for example, in Ontario and in Alberta. And those acts say that an arbitrator may be challenged if circumstances exist that may give rise to a reasonable apprehension of bias. And that is, as the word suggests, an objective test. The reasonable apprehension of bias must be a reasonable one held by reasonable and right-minded persons. What would an informed person viewing the matter realistically and practically and having thought the matter through conclude? And that test comes from a Supreme Court of Canada decision called Committee for Justice and Liberty Canada, National Energy Board, 1978, 1 SCR 369. And I will be sending you a link to that case after this seminar with the video recording. It's considered to be a probability of bias test. That's the domestic test. The international test, on the other hand, is called a justifiable doubts test, and we see that in the model law. We also see that in the BC Domestic Act, and we see it in a lot of the institutional rules that parties adopt. The model law says that there will be a challenge only if circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality or independence. And so we distinguish those two by calling the first the reasonable apprehension of bias test and the second as the justifiable doubts test. But what is clear, I think, from the case law and confirmed in Aroma is that they're really the same test. The same language, the justifiable doubts test, also appears in the BC Act. However, there is an additional hurdle that parties seeking to challenge the arbitrator must achieve under the BC Act, and that is there must also be a real danger of bias. And I understand that that additional test was created to address the increase in frivolous challenges that we see increasingly making their way through the courts. So the case law says that both the reasonable apprehension of bias test and the justifiable doubts test are objective, and you'll see in some of the case law that they're used interchangeably. So in an international arbitration where the justifiable doubts test applies, you'll see the case law talking about the reasonable apprehension of bias test. So the question in Aroma is whether the duty to disclose test is objective or subjective. So I'll now take you to the arbitrator's duty to disclose test. And again, it's expressed in different language in the domestic and international arbitration. So in the Ontario Act, for example, the arbitrator must disclose any circumstances of which the arbitrator is aware that may give rise to a reasonable apprehension of bias. And the model law says that the arbitrator must disclose circumstances likely to give rise to justifiable doubts as to the arbitrator's independence or impartiality. And that's the language that also appears in the BC Domestic Act. Now, Aroma says this is also an objective test, and that very question is at issue in the Aroma case. So we're almost going to get there, but we're not there yet. So where does this duty to disclose or bias test come from? So I've shown you that the legislation provides a duty to disclose and a bias test, but there are also multiple sources. So there are different institutional rules that parties have adopted, which may have slightly different language, in which case there may be slight differences between the language in the legislation and in the rules. And for the most part, the rules chosen by the parties will override that legislative language, but it's absolutely essential for parties and counsel and arbitrator to understand if there is slightly different language and what that means. There are rules of professional conduct to which arbitrators who are lawyers are subject, and that may provide additional guidance or hurdles with respect to disclosure of conflicts of interest. And then there is soft law. And the most important document for this topic is the IBA guidelines on conflicts of interest in international arbitration, a very well-known and often consulted document that is used not only in international arbitration, despite its title, but also in domestic arbitration. It is non-binding, but it is extremely influential when decisions are being made about disclosure and challenges are being made to the independence of arbitrators. So it's used by courts, it's used by counsel, and it's used by arbitrators. It provides guidance on when the duty to disclose arises, and that is the complicating issue in Aroma. It is an international standard, and it was created for the purpose of allowing for parties and counsel from different legal traditions around the world to have a common expectation about when the duty to disclose arises and the kinds of circumstances in which the duty to disclose arises. So both the test and the circumstances that should be considered when an arbitrator is making a duty to disclose decision. So I'd like to dig a little deeper in those IBA guidelines because, again, they're central to the Aroma case. They provide both a test for disclosure and disqualification and circumstances, a list of factual scenarios which assist an arbitrator in determining when the duty to disclose arises. So first of all, what is the test for disclosure and disqualification? The duty to disclose arises if facts or circumstances that may, in the eyes of the parties, give rise to doubts as to the arbitrator's impartiality or independence. And the significant language that appears in the IBA guidelines that does not appear in the legislation is the requirement that facts or circumstances must be disclosed if, in the eyes of the parties, which is a subjective element, it gives rise to doubts about the independence or impartiality of the arbitrator. So this language, therefore, is a departure from what the model law says, which says nothing about a test involving the circumstances when viewed from the eyes of the parties. There's also guidance, as I've said, on when disclosure should be made by providing long lists of circumstances which may or may not require disclosure. And these circumstances are based on certain categories which follow a traffic light system. So there are various categories of circumstances which fall into either a red, an orange, or a green category, and each of those categories means something. So the red list says that there's a duty to disclose and a clear conflict of interest, which means that if they're on the waivable list, you cannot even ask parties for their consent to waive the conflict. The arbitrator must decline the appointment. And these or resign if the arbitration is in progress. And these are very obvious circumstances that will surprise no one. For example, there's an identity between the arbitrator and a party. For example, an arbitrator who is a director of a party involved in the arbitration must not accept the appointment. That is not something that the party should be asked to or could waive. There's then a waivable red list where justifiable doubts about the arbitrator's independence or impartiality could exist, but that depends on the circumstances. And parties can consent to the arbitrator being appointed with full knowledge of the circumstances and in providing their consent. And one example is the arbitrator has given legal advice or had prior involvement on the specific dispute which is at issue. And I suggest that although there are circumstances in which the parties could consent with full knowledge of the circumstances, this is very likely a circumstance in which no party could or would consent. So really the red light circumstances are off the radar. Then there are orange light circumstances where the circumstances may, in the eyes of the parties, so we see that language again, give rise to reasonable doubts, in which case there is a duty to disclose. So all of the orange category circumstances give rise to a duty to disclose. And this is the most difficult category, the most complex circumstances, and this is the category in which the Aroma case falls. Before I get there, the green list are circumstances which should never give rise to disqualification, and there is no obligation to disclose. For example, an arbitrator has previously given an opinion about a specific issue that's relevant to the arbitration in an academic article, for example. Or the arbitrator and counsel have previously served as arbitrators. Now, I would suggest, as a result of Aroma, we might want to rethink in Canada some of the items on the green list, and we may put them into orange list categories. And what you'll hear about as I continue is that these categories are not easy to interpret. And they are actually quite complicated. They're well accepted, but they're not clear, and there are no guidelines that will absolutely determine under the orange list whether the case falls within or outside, and whether disclosure is required. They're very detailed. They go some 50 some pages, and they still do not give a definitive answer in many circumstances about whether disclosure is required. They're not watertight compartments. And there's really no definitive answer in many situations about whether there is a duty to disclosure. So they're consulted often, but one might ask oneself, how helpful are they? And my answer to that is they're certainly helpful in prompting arbitrators and counsel to give consideration to how close the circumstances before them are to the circumstances in the list, and to have a more educated decision-making process on when the duty to disclose arises. So some of the most common grounds for arbitration challenges, certainly in Canada, are multiple appointments by the same party. And this is the Aroma case. And in the Vento Motorcycles case, it's a pre-existing relationship with a party, an affiliate, or counsel that commonly raises challenges. The rules say that a counsel who makes disclosure of potential problems that could give rise to reasonable apprehension of bias or justifiable doubts is not an admission that there is bias or there are justifiable doubts. This is an obligation to make disclosure of circumstances in which the arbitrator believes that may give rise to justifiable doubts, but not an admission. And a party that wishes to challenge the arbitrator's bias or independence and independence and impartiality must still prove that. The consequences, though, of a failure to disclose and the challenge of an arbitrator on that basis are very serious. The arbitrator may be disqualified, may be removed, may be forced to resign, and the award may be set aside. So these are very serious decisions that get made both at the outset of the arbitration and throughout. The legislative authority for a challenge to bias is in the Domestic Act, the model law, and you'll also see many different processes set out in the institutional rules that parties adopt. But for example, under the domestic and international law, a party may challenge an arbitrator if circumstances exist that may give rise to reasonable apprehension of bias or justifiable doubts. So that's the test. The court may remove an arbitrator if the arbitrator does not conduct the arbitration in accordance with equity, equality, and fairness, and the parties shall be treated with equality and fairness, and each party shall be given an opportunity to present its case. So the arbitrator has an obligation to treat the parties fairly, and without doing so, may be challenged. The legislative authority for setting aside a final award really does focus on the composition of the tribunal, for example, and that's under the set aside provision. So other than in BC, there is no specific ground in the set aside provisions for setting aside the award on the basis that the arbitrator is independent or impartial. There are other grounds in the model law. So the composition of the tribunal was not in accordance with the arbitration agreement. The procedure was not in accordance with the parties' arbitration agreement. And then again, one of the parties wasn't treated fairly. So finally, let's get to the Aroma case. So this was a motion to set aside the award on the basis of breach of the arbitrator's duty to disclose and reasonable apprehension of bias. So it was an Ontario case, it was an international case, but the court used the words reasonable apprehension of bias rather than justifiable doubts. The case is about whether the arbitrator ought to have disclosed in the first arbitration, the Aroma arbitration, a later appointment by the same arbitrator who was counsel in the Aroma arbitration in arbitration 2 while arbitration 1 was ongoing. So they were simultaneous arbitrations by the same arbitrator, and the second arbitration was not disclosed in the first arbitration. And the question was whether those circumstances gave rise to a reasonable apprehension of bias and whether the arbitrator failed in his duty to disclose. The two arbitrations were entirely unrelated, no similarities in facts or the legal issues. And the counsel in the first arbitration learned after the award had been issued that the second arbitration had gone ahead with the same arbitrator and moved to set aside the award. This was a situation in which it wasn't clear under the IBA guidelines whether the arbitrator had a duty to disclose. And so that was what was before the court. The first level decision focused on the circumstances. What did the arbitrator know? And looked at the IBA guidelines. So here are some of the facts which were critical to the lower level court's decision. The parties' agreement required that the appointment of an arbitrator with no prior business or professional relationship with the parties. That was not a problem in this case. The pre-appointment correspondence between counsel made it clear that the parties would not agree to an arbitrator who had any relationship with one of the counsel. So this was different than the provision in the arbitration clause. And it was this exchange of correspondence which ultimately resulted in the appointment of an arbitrator whom the applicant argued had a relationship with the counsel for one of the parties that ran afoul of what the parties intended. And the lower court decision was that there was a breach of the duty of disclosure. The arbitrator ought to have disclosed in the first arbitration that he had taken on a second arbitration with the same counsel as was counsel in the first arbitration. And in doing so, the lower court decision looked at the IBA guidelines on conflicts of interest in international law. And this was an orange list case. The IBA guidelines said disclosure may be required where there is an appointment made by the same party or the same counsel appearing while the case is ongoing, depending on the circumstances. And so this is, of course, where the analysis becomes difficult, because are these circumstances which fall within this prohibition? Here, the circumstances, according to the lower level judge, gave rise to a reasonable apprehension of bias because the judge found that the optics weren't quite right. There was evidence from the parties that had they known, they certainly would not have agreed to the appointment of this arbitrator. So she happened to let in evidence of the parties' views after the issue came to light, and on the basis that the parties' counsel's correspondence was consistent with that. So she found that the parties would not have agreed to this appointment. She thought that the optics weren't great in part because the arbitrator was earning money from arbitrations. And so the suggestion, never explicitly set out, was that the arbitrator would be eager to take on mandates because of the income, that it was suspicious that the disclosure didn't happen, even though the second arbitration took place for a long period of time while the first arbitration was taking place. And she called that she described that as a hidden circumstance. And so for all of those reasons, the sense you get is she's just quite critical of how the whole thing transpired and why this second appointment was made when that arbitrator had never been appointed by this council before. It just left a bad taste in her mouth. So here are my thoughts on this case. The evidence was clear that the arbitrator saw the arbitration agreement, which prohibited an appointment of an arbitrator that had a relationship with the parties. But the evidence wasn't clear, and the lower court decision did not find explicitly that the arbitrator knew that counsel and the parties also would not agree to an arbitrator appointment with somebody who had a relationship with counsel. And that is absolutely necessary, in my view, to understand the way the lower court decision was made and the reasons, even though it wasn't an explicit finding. The Ontario Court of Appeal found otherwise, and this is central to the reason that the Ontario Court of Appeal overturned the lower court decision. The lower court decision focused a lot on the relevant IBA guidelines. And I think when I read some of those guidelines to you, you'll appreciate the difficulty that arbitrators in these circumstances face. We don't know what the arbitrator's analysis was, but the Orange List said that there was a duty to disclose because circumstances may, in the eyes of the parties, give rise to doubts as to the arbitrator's independence and impartiality. So there was an element of a subjective test, and the judge relied upon the exchange of correspondence between counsel, which said no relationship between the counsel will be permitted. So therefore, in the eyes of the parties, this appointment would never have happened. There is a specific circumstance listed in 3.3.8 in the Orange List, which says that there is a duty to disclose if the arbitrator has, within the last 3 years, been appointed on more than 3 occasions by the same counsel. And in this situation, those criteria were not met because the arbitrator was appointed twice, not 3 times. Why do the IBA guidelines refer to 3 appointments rather than some other number? No answer to that question. It just kind of sounded right, presumably by the committee that drafted them. But you can see how difficult it is for an arbitrator to conduct that analysis. Well, the guidelines say I don't have a duty to disclose where there are fewer than 3 appointments. But there's another part of the Orange List commentary, which says that situations not listed in the Orange List are generally not subject to disclosure. So if it doesn't fall in the list, there's no requirement to disclose. However, arbitrators need to address this on a case-by-case basis, and in particular, an appointment made by the same party or the same counsel appearing before an arbitrator while the case is ongoing may have to be disclosed, again, depending on the circumstances. So, in my view, it's not clear under the IBA guidelines whether the circumstances in Aroma fall under the must disclose or need not disclose category. So you can see how difficult it is for arbitrators to make decisions. And this is just one example of an exercise that is done every time there is a potential for an appointment. So here, lower level judge applied the IBA guidelines and said these circumstances, based on the specific facts, particularly because of this exchange of correspondence, required the arbitrator to make disclosure, therefore breach of the duty to disclose, and um, um, reasonable apprehension of bias. So the Ontario Court of Appeal then considers this case and overturns both of those findings. Firstly, the facts, it found different facts than the lower court decision. And ultimately, I say this change in the factual findings determines the outcome. So the application judge said that the arbitrator knew of the term of in the arbitration agreement that there could be no appointment by an arbitrator that had a relationship with the parties. Agreed. The Ontario Court of Appeal says that's absolutely clear. The arbitrator had that knowledge, and this is not what the complaint was about. However, the Court of Appeal says there's no evidence that the arbitrator knew about the negotiations of counsel. So the arbitrator had no idea that because he was being appointed by the same counsel in a second arbitration, that this was a no-go situation for the parties. The application judge erred in introducing these subjective considerations that the arbitrator knew nothing about into the disclosure decision. Further, the Ontario Court of Appeal said there really were no similarities between the issues or the facts in the two arbitrations. So, without that knowledge, the Ontario Court of Appeal said this was not a situation in which there was a duty to disclose. So, no duty to disclose and no reasonable apprehension of bias. The court below also applied the wrong test for the duty to disclose, and that test was the one found in the IBA guidelines, which introduced this subjective element to the test. The model law, which was applicable because this was an international arbitration, contained no language about the specific subjective views of the parties. It simply says there's a duty to disclose if there are any circumstances likely to give rise to justifiable doubts. And the Ontario Court of Appeal said this is an objective test. And the court below erred in introducing the subjective element of the test. And the court said the IBA guidelines have no application whatsoever to this case because the parties did not adopt them. And so, quite apart from the fact that the lower court erred in referring to facts which were not known to the arbitrator when he was making his disclosure decision, the court applied the wrong test. It should have been an objective test. And based on the objective test, there was no duty to disclose and no reasonable apprehension of bias in these circumstances. And essentially what the court did was a legislative interpretation exercise and found that the language in the model law is an objective test. So here the court said the presumption of arbitrator impartiality, which is another topic, and that is that arbitrators have a presumption of impartiality, which the party challenging the arbitrator must overcome. This presumption of impartiality was not displaced by the circumstances in this decision. So what does all this mean and where are we now? So the Ontario Court of Appeal has said that the IBA guidelines do not apply for the disclosure test unless they're adopted by the parties. And as I said in my introduction, this is not consistent with international standards. And the Supreme Court of Canada has said that Canada should be lockstep with international standards, in part because there is an interest in having Ontario and all the provinces, and under the International Act, making Canada and its various jurisdictions an arbitration-friendly place. There are a whole bunch of reasons for that, including attracting business to Canada. And so the court said that the fact that the IBA guidelines don't apply is consistent with the language in the legislation, but I say it's not consistent with what's happening in the international scene. Most of the case law dealing with this issue comes out of Ontario. So at the moment, this is really an Ontario issue, but there is no doubt that as challenges arise, the other provinces will have to deal with that, and it'll be interesting to see what they say about it. But I think what is most important about the Ontario Court of Appeal decision is that it's the only one that really undertakes a rigorous analysis about the difference between what the test should be under the IBA guidelines and what use can be made of the IBA guidelines, even if the test is not being applied. And the Court of Appeal said they are definitely useful for viewing the circumstances that may give rise to a duty to disclose because of the various circumstances, including those that I've listed, may help with the decision making that arbitrators will have to make in making that duty to disclose. But it doesn't set out the test for the duty to disclose. That is found in the international law unless the parties adopt the IBA guidelines, in which case that duty to disclose governs, and it is the subjective case, the subjective standards. So lots of questions, but the fact that the Ontario Court of Appeal has now actually set out an analysis which the other courts will consider, I think is a step ahead. The other thing the court has said is that consistent with the IBA guidelines, the test for disclosure is broader than the test for satisfying the bias test because of the language in the duty to disclose test, which is slightly different than that for the challenge test. The court says an arbitrator has the obligation to disclose a far greater span of circumstances than would constitute a breach, which would constitute justifiable doubts or reasonable apprehension of bias. So where we are now, Ontario is the outlier internationally, and it has also set out an approach which I think will be useful to other courts. So I do want to say a few things just about the Vento case. Both Vento and Aroma were before the Supreme Court of Canada, and leave was denied this year. So Vento Motorcycles was an application to set aside an award on the basis that one of the tribunal members was biased. It was an international arbitration. One member of a tribunal of 3 disclosed before his appointment that he had a friendly relationship with one of the counsel for the parties that nominated him, and it was Mexico. The other party had no objection to the disclosure of this information. However, during the course of the arbitration, the Mexico counsel and that arbitrator continued to have a number of ex parte communications in which the referred to each other by first name, which suggests to me that the relationship was fairly friendly, which is what was disclosed. But counsel advised the arbitrator that he was working to get him placed with a number of prestigious and potentially lucrative arbitration rosters. And it so turned out there were a number of exchanges in which, for example, counsel for Mexico said, "Would you please send me your resume so I can forward it on to get your name put forward for these rosters?" And it turned out that the day the arbitrator was notified that he had been accepted on the roster, it was the very day that the award was issued. The applicant who discovered the extent of this relationship and these third-party communications learned after the award was issued and moved to set aside the award and relied on the IBA guidelines as an authoritative source of how arbitration communications can be regarded in certain fact situations. So this is the Ontario court adopting the IBA guidelines for that purpose, but this lower level decision also applied the IBA guidelines for the test, the duty to disclose test. And that decision was made before the Ontario Court of Appeal decision in Aroma, but I think it's an example of the fact that some of the earlier case law uses the IBA guidelines for both purposes and doesn't really distinguish between its use to determine the test and its use for a review of circumstances which may give rise to a duty to disclose. The court found that there was a reasonable apprehension of bias using the objective test because which if the court found was objective, notwithstanding relying on the IBA guidelines. So this is kind of an indication of how a reasoned analysis is really critical in this area. And because there was a reasonable apprehension of bias, there was a duty to disclose, which is not the way the analysis is supposed to go. Ideally, it starts with a duty to disclose, and failure of which may or may not give rise to a finding of reasonable apprehension of bias. We then go to the Court of Appeal, and the appeal was granted on the basis that that the lower level court had decided to exercise her jurisdiction to not set aside the award under the set aside provisions of the model law. That was an issue that resulted in the overturning of the ultimate decision, but there was no challenge to the bias finding. So if the Aroma decision hadn't been rendered by the Ontario Court of Appeal, this would have been another example of a few in which courts were using both the guidelines for both the determination of the test and to determine the duty to disclose. This, in fact, was a fairly easy duty to disclose test. So the real analysis comes out of Aroma. So my takeaway, I think, from a review of both of these cases and comparing to some of the earlier case law, which I refer to in the list of resources that I'll send to you with links, is that the purpose of the IBA rules guidelines is to impose some international consistency. They say that in the introduction. There are parties participating in international arbitration who come from a variety of legal cultures, a variety of legislative regimes, and in order to make for consistency in expectations and results, the IBA constituted a committee of various arbitrators from across the world to come up with best standards that would apply regardless of the legal regime from which the lawyers and the arbitrators and the parties came from. And this is what they came up with. So according to the IBA guideline writers, this subjective element to the duty to disclose is best practices and should be adopted worldwide. So I think that's an interesting and important fact to consider when considering the Ontario Court of Appeal decision. The other, I think, very important point is the IBA guidelines, for whatever use they may be, do not provide concrete answers in most cases. So there is a fair amount of ambiguity, and really the arbitrator's judgment comes into play regardless of whether they apply or not. They always depend on the circumstances of the case. And so regardless of whether we have now reached the point in the Aroma case where we at least have an analytical framework, it doesn't really get us to, I think, more certainty in decision making. And it's not clear whether any guidelines of the kind that the IBA guidelines will ever be able to do something to get us more certainty. It certainly does raise questions and cause counsel, arbitrators, and parties to give consideration to a wide variety of circumstances they may not have otherwise considered, which in my view is useful. Now we're really seeing a lot more court challenges. So I think that this issue is going to come up again and again and again. And as I said, we're maybe going to see whether other courts in other provinces agree with this approach. So this is all I have to say about Aroma and the duty to disclose test. I don't see any questions in the Q&A box, although I'll give you a few minutes to think of any. But I'm going to conclude in saying that my next arbitration boot camp will be in January. I know that everybody is working at a frenzied pace to get everything they need done by the end of the year. So I decided to have a November boot camp and not a December one, but I'll be back in January. And I will be talking about appeals. There are lots of issues to talk about when it comes to appeals. So thank you so much for joining me. I hope you found this useful and have a great day. We'll see you next time.